Hello aspirants, welcome to Spardha Line. Today is the sixth session of the complete Indian Polity Through MCQ, and this is the third part of fundamental rights where we are going to finish the fundamental rights. Those who are not seen the first two parts, they can watch the first two parts where I have covered each fundamental rights, the exceptions in there, and what is not covered in M. Lakshmikant, that also I covered there. So kindly watch these two videos and then come to watch this particular video. So we'll start our discussion. Before going to discussion, I have one small announcement that in Spardha Line we are launching one batch, that is NCERT Foundation Test Series. In this batch, the features is first feature is this batch is module wise, where you can buy or you can register for which module you want, where you find yourself weak, or else you can, if you are feeling your base is not so strong, you want to make your foundation strong, then you can register for all the modules. Second feature, we are integrating the questions from the NCERT, DSRTC and previous year questions from the UPSC, KPSC, NDA, CDS and other examinations. The people who are struggling to clear the UPSC, KPSC prelims, they can join this batch. Also the beginners who are just starting their preparation and they want to make their base strong, they can join this batch. Also the aspirants who are opting for the other examination, Group C examination, SSB will be there, and other railway, RRB, they can also join this batch. The detailed schedule and the syllabus given in description section, kindly go through it and register. Seats are limited. Already there are the seats are full, so kindly register as early as possible. So we'll move towards our discussion where we are going to see Indian polity through the MCQ. So the first question for today's session is about Article 23, which one we skipped last time. So we are going to cover this one. This question particular talks, first statement, Article 23, it prohibits forced labor and enforceable against both private individuals and the state. Second, working for less than minimum wage is considered as forced labor under Article 23. Okay, this I guess these questions particularly we have covered earlier also. For the revision purpose, I have brought this question. So this particular, say if you say this Article 23, it covers the forced labor and it is enforced against private individual as well as against the state. And second aspect, the working for less than minimum wage considered forced labor, Article 23. It is also correct because the force that mentioned in Article 23, it is not only the physical force but the economical also, where person cannot be compelled to work below the minimum prices. So the both statements are correct. Correct answer is C. Both 1 and 2 are correct. We'll see the next question, which is about Article 27. So this particular question says that no person shall be compelled to pay any tax for the promotion of any particular religion. Second statement, the state can use the religion for the promotion or maintenance of all the religions. Third statement, the provision permits the levy of fees for the regulating the secular administration of the religious institutions. So pause the video, answer the question. Those who are compatible in Kannada, they can read the Kannada also. Okay, we'll see which statement is correct. First says that, first Article 27, which gives the freedom to all the citizens from taxation for religious purpose. Okay, so first statement says no person shall be compelled to pay any taxes for promotion of any particular religion. Statement is correct because the Article 27 it gives the freedom from taxation for promotion of any religion. Okay, second says that the state can use the taxes for the promotion of religion, maintenance of all religion. There is a second factor when it comes to Article 27. So the person, they cannot forced to forced to pay the tax for promotion of any religion, it means the state or the government also cannot use the tax money that is collected by the people for promotion of one religion. Okay, but India being a secular country, and our secularism is the equal respect to all religion or the equal distance from the all religion, state can use the tax money for promotion of all the religion. So it is kind of our secularism where we are treating the all religions equally. So that in this case the second statement also becomes the correct. Last one, the provision permits the levy of the fee for the regulating secular administration of religious institution. This is also correct, because the fee for the secular administration, for example, constructing toilets outside the temples or the other religious places, the parking, okay, construction parking buildings. So these are the secular administration or the secular purpose, where for this purpose the fee can be imposed, and this permitted in the constitution. So all three statements are correct. Correct answer is D, that 1, 2, 3 are correct. We'll move toward the next question. So it is about again the article 28, which says that in which of one of the following educational institutions is imparting religious instruction permitted without any exception. The first A option is the institution wholly maintained by the state, institutions administered by the state but established under any endowment or the trust, institutions recognized by the state, institution receiving aid from the state. So let me know which is the in which of these four educational institutions the religious instruction is permitted without any exception. Okay, pause the video and answer the question. Okay, we'll see which one is correct. First, going to answer, just we'll brainstorm article 28, which gives the freedom from attending religious instructions. Okay, now we need to see in which of the educational institutions we can enjoy this freedom. Now the first, it says, the question is saying without it asking religious instruction permitted without any exception. Okay, so we need to read the question very carefully to answer correctly. So the first statement you see, institution wholly maintained by the state. Here the religious instructions are strictly disallowed. Okay, the religious instruction at any exception should not be given. Okay, so this is the first statement. So the first option is not correct. Second, institutions administered by the state but established under any endowment or trust. Here the religious instruction can be given, so the correct option is B. Now if we see the C and D, institution recognized by the state, institution receiving aid from the state. When it comes to these two kinds of institutions, the religious instruction, here also religious instruction is permitted, but there is exception that before giving the religious instruction, the consent of person is needed. So the without consent of the particular person, the religious instruction cannot be given. When this person is under 18, that time the consent of his or her parents needed. So here the exception involves, and what is question asking? Without any exception. So the less instruction permitted, but there is exception. That's why the C and D cannot be the answer. So this way, this is what we need to read the Lakshman very carefully and need to interpret the its text very smartly. Okay, and this interpretation should hold the spirit of the text. Okay, we'll move toward the next question. It is about the Article 29. So it says that Article 29 provides that any section of citizen has right to conserve its distinct language, script, and culture. Second statement: no citizen shall be denied admission into any educational institutions maintained by state, receiving aid from the state fund on the ground of only religion, race, caste, and language. Last statement: Article 29 grants protection to both minorities and majority community as well. Okay, so pause the video and answer the question. Okay, we'll see which one is correct. First statement says Article 29 it provides that the any section of citizen has the right to conserve its distinct language, script, and religion. This statement is correct. Supreme Court, this any section, this interpreted liberally. Where it comes to any section, it includes the majority and as well as the minorities. So the this statement also correct, and with this third statement also becomes correct. Okay. Second statement: no citizen shall be denied admission into any educational institutions maintained by the state, receiving aid from the state funds on the ground of religion, race, caste, or the language. So this statement is also correct. Correct answer is D. That 1, 2, 3 are correct. Before the finishing, just I will want to give some explanation here. The any section of citizen, it is interpreted majority and minority. Now, when it comes to Article 29, these are the cultural and educational rights. And what comes here? Article 29 and Article 30 comes under this particular educational and cultural rights. Now, this Article 29 and okay, until the Article 29 concern, it is talks about the individual right, the individual right of the person, as well as the community right. Okay. So when it comes to community right, these two statement becomes the correct. Okay, those two first and third statement, these are the related to community rights. And the second statement, there is no citizen shall not be denied admission in any educational institution on the grounds of religion, race, caste, and language. Condition is that these institutions should be maintained by the state, or it must be receiving aid from the state. Okay, so this is talking about the individual right. Okay, there are the what is the crux? There are the two types of right, that is the individual right as well as the community right. Okay, we'll see the next question. It is again Article 30. It says that all minorities have the right to establish administer educational institution of their choice. The protection under Article 30 is confined only to minority, does not extend to majority communities. The right under Article 30 includes the right of the minority to impart education to its children in its own language. Okay, pause the video and answer the question. Okay, just we'll see the statement. All minorities shall have the right to establish, administer education institutions of their choice. Correct. And when it comes to minority, these are not just religious minority but the linguistic minorities. Okay, so these are two aspects, that is linguistic minority as well as the religious minorities. Second, the protection under Article 30 is confined to only to minorities, does not extend to majority. Yes, because the section of citizen, it is interpreted as a minority and a majority in Article 29 only. But when it comes to Article 30, it is only confined to the minority and not extend to the majority. So this is the one aspect. Third statement, the right under Article 30 includes the right of the minority to impart education of its children in its own language. Yes, this also correct. This aspect also covered under this particular Article 30. So the correct answer is D. This 1, 2, 3 are correct. Now when it comes to the Article 30, there are some basic facts that we need to understand. When it comes to Article 30, this is also correct. With this, if the government wants to take over the property of these minority education institutions, property of minority educational institutions, then the government, they need to give the fair compensation to these minority educational institutions. So you all know the Article 31, which given the right to, previously talk about the right to property, but now it is not removed. It is no more fundamental right, but it is a constitutional right. But still the right, there are the two provisions which carries the right to property. One is this one covered under Article 30. It's about the minority educational institutions. Okay, so these, when the government wants to take over their property, they need to give the fair compensation. Okay, second aspect, when it comes to these minority educational institutions, there are the three types of, when first is they receive aid from the state. Okay, second is they receive aid and recognition from the state. Third is they don't receive aid or they not receive recognition from the state. So in this condition, okay, no, first comes that they receive only recognition but not aid. Second is that they receive aid as well as the recognition, and the third type of minority education institution is they neither receive aid, neither receive recognition, or receive recognition. So in these first two kind, they are all the subject to, or the state's capacity to enforce or regulate. Okay, it applies to this first two type, but when it comes to the third, state cannot regulate them. Okay, but the general laws are there. Okay, contract act are there, other sanitation, the workplace related laws, that can be applied for this third type of educational institutions. So this is the small information about the Article 30. We'll move toward the next question. Okay, so the next question is which of the article in the Constitution was described by B.R. Ambedkar as the very soul of the Constitution and the very heart of it? Okay, there are the four options. Pause the video, think on it, and let me know the correct answer. Okay, we'll see what is the article, what is about this particular statement, to which article B.R. Ambedkar says that very soul of the Constitution and the very heart. It is the Article 32, which gives the right to constitutional remedies. Indirectly, this particular Article 32, it is giving you right to, or we have the fundamental right to enforce the fundamental rights. If the Article 32 is there, 32 is not there, then we cannot enforce the other fundamental rights. So the Article 32 dies, the fundamental rights dies. So that's why it is called as a very soul of the Constitution and the heart of the Constitution. If soul is not in body or heart is not in body, then body will not be function anymore. So that's why it is called Article 32 is a soul of the Constitution or the heart of the Constitution. Okay, we'll see the next question. So it is again about Article 32. It is quite important one. That's why I have put more questions here. That the president can, it is asking which of the following statements are correct. So it says that the president can empower any other court to issue direction, order, and writ of all kinds. Second, the parliament can suspend the right to move any court for enforcement of fundamental rights during national emergency. Third one, the right to move the Supreme Court for the enforcement of fundamental rights shall not be suspended except otherwise provided by Constitution. Okay, pause the video, answer the question. It is quite tricky, quite confusing. Pause the video and let me know the correct answer. Okay, we'll see which one is the correct. The president can empower any other court to issue direction or the order, writ of any kind. So currently under Article 32, the only Supreme Court, the Supreme Court of India, it can issue the all kinds of writ. Okay, it might be habeas corpus, the mandamus, certiorari, prohibition. Okay, this kind of writ allowed to enforced by the Supreme Court only under Article 32. When it comes to High Court, it is Article 226. Okay, but it is not the president but the Parliament. The Parliament of India can empower any other court. Any other court means other than the Supreme Court and the High Court to issue direction, order, writs of all the kinds. Okay. Second statement: the Parliament can suspend right to move any court for the enforcement of fundamental right during national emergency. Not a Parliament again. It is the President of India. He can suspend the right to move any court for the enforcement of fundamental right during emergency. Third statement: right to move to Supreme Court for the enforcement of fundamental right shall not be suspended except otherwise provided by Constitution. Yes, the Article 359 and Article 358. These two articles which deals with the suspension of fundamental rights during time of the national emergency. So the Constitution itself provided during the what time the fundamental rights can be suspended. Okay, and the not all fundamental right, but the except the Article 20 and Article 21. Except these two, all the other fundamental rights can be suspended. But here is talking about right to move Supreme Court means it's talking about Article 32. Okay, this can be suspended under Article 359, and this is done by the President itself, not by the Parliament. So the first two statements are wrong. Third is correct. So correct answer is B. The 3 only is the correct. We'll move towards the next question. It is again about the with reference to enforcement of fundamental right under Constitution. Okay, so it says that the original jurisdiction to enforce the fundamental right lies with the Supreme Court, but it concurrent with the jurisdiction of the High Court. Second statement: High Court also possesses original power to issue direction, order, writs of all kind for the enforcement of the fundamental right. Now there are two tricky words included in these two statements. Pause the video and answer the correct. Okay, we'll see which one is the correct. First, it talks about the original jurisdiction to enforce the fundamental lies with the Supreme Court, but it is concurrent with the jurisdiction of High Court. Correct. Okay, the original jurisdiction, it is lies with the Supreme Court, but again it is concurrent with the jurisdiction of the High Court. Second statement, the High Court also possesses the original power. Original power means first to enforce. Okay, and this particular original power, according to Supreme Court said that if the remedies lies with the High Court, then the aggrieved person first, he should go to High Court under Article 226, and if the High Court is not satisfied, then that person can go to the Supreme Court. So in this case, this statement becomes correct. Now when it comes to this writ jurisdiction, there are the two aspects that we need to understand. That when it comes to High Court, it can enforce the fundamental right and other constitutional rights through the writ jurisdiction. But when it comes to the Supreme Court, it can only enforce the fundamental rights through the various writs, be it habeas corpus, be it mandamus, be it certiorari, or the quo warranto. They can enforce only fundamental rights, not other their constitutional rights. Okay, that's why the power of the Supreme Court is limited when it comes to this particular aspect of enforcement of fundamental right. Okay, that's why the original power lies with the High Court. And when it comes to the territorial jurisdiction to enforce the writ, it is more with the Supreme Court, because Supreme Court can enforce for the all over India. When it comes to High Court, it can enforce for the territory of that particular state, or the High Court is established for the which, if it combined High Court is there for two states, then it can enforce for these two states. Or if there is only one High Court for one state, then it can enforce in that particular state only. Okay, so this is you need to know about the writ jurisdiction. We'll move toward the correct answer is the C, that both are the correct. Okay, we'll move toward the next question. It is about the habeas corpus. It talks about it empowered the court to examine cause and legality of detention. Second, the writ of habeas corpus can be issued only against the public authorities. Third, habeas corpus can be issued even if the detention is lawful. Okay, pause the video and answer the correct. Let me know which is the correct one. Okay, we'll see which one is the correct. First is that it empowers the court to examine the cause and legality of detention. First, when it comes to the habeas corpus, it is Latin term for to have body of means it is asking to present the body. If anybody has seen the film called Jai Bhim, they knows, because in this particular film it is revolves around the repetition of habeas corpus. Okay, so it says that to present the body of person detained. So that's why it is empowered the court to examine the cause and legality of the detention. If person is detained, so the court can go and see the legality of detention, also the causes behind the detention. So the detention can be lawful and for the purpose. Okay, so that's why it is called a habeas corpus is the individual bulwark of individual liberty, because the person cannot be detained arbitrarily, and if detained arbitrarily, the other person can go to the Supreme Court or the High Court under the habeas corpus, and the court can check the cause and legality of the detention. Second statement, the writ of habeas corpus can be issued only against the public authority. No, because these public authorities such as police, other paramilitary forces are there, military is there, they can detain the person. Also the other people, other in the sense private people, they might detain some person, or the kidnapping kind of cases this comes. So that time the habeas corpus can be issued against the private individuals. Last, the habeas corpus can be issued even if the detention is lawful. No, even if detention is lawful, that time habeas corpus cannot be issued. So detention, when it will be lawful, when it is the detention is permitted or the allowed by the court. The detention against the contempt of court or the legislature, or to serve the period in the sense, if person is done some offenses and he is serving the punishment, that time the detention become lawful, and this is not covered under habeas corpus. So the correct answer is A. This only one is correct. Okay, we'll move toward the next question. It is about the mandamus writ. Okay, second writ. It command issued by the Supreme Court to any person asking him or her to perform his or her official duties. Second statement, it can also be issued against the tribunal, government, governor, or the president. Third statement, the writ of mandamus can be issued against the private individual or the body performing the public function. Okay, pause the video and let me know which one is the correct option. Okay, so we'll see which one is the correct. First statement says it is the command issued by the court to any person asking him or her to perform his her official duties. Yes, this time the mandamus can be issued against the mostly the official duties who performs the public authorities, and sometimes the private individuals. In case of deputation, they also perform this official duties. So that time the mandamus can be issued against them. Second, it can also be issued against the tribunal, government, governor, and the president. It can be issued against tribunal, the lower court, but it cannot be issued against the governor or the president. So second statement becomes the wrong. Last statement, the writ of mandamus cannot be issued against the private individual or body performing public function. Okay, this becomes wrong because the mandamus can be issued against the body performing the private body that is performing the public function. So this statement becomes wrong. So now against whom this mandamus cannot be enforced? The first we have seen, it can be enforced against the tribunal the court, okay, inferior court, and other the public persons who are not performing their, or the private persons who are not performing public duty, against them cannot be enforced. It means the private individuals who are not obliged by the public duties. Second, it cannot be issued against the body which don't have the statutory force to perform the body. Okay, the body is merely advisory. In that case, this mandamus cannot be enforced because it don't have the statutory force to enforce its duty. Third, it cannot be issued against the governor or the president, the chief justice of high court. It cannot be issued against them, and also it cannot be issued against the legislatures. Okay, which kind of legislature? The parliament, as well as state legislative assembly and state legislative council. So against them it cannot be issued because of we have the separation of power. So that's why it is not be issued. So the second and third is wrong. So correct answer is A, that only one is correct. We'll move toward the next question. So it is about the certiorari. Okay, it talks about the writ of prohibition is issued before the final order is passed by judicial and quasi-judicial authority. Second statement, the writ of certiorari is issued after the final order is passed and for quashing the same. Last statement, like the writ of prohibition, the writ of certiorari is also considered judicial writ. Okay, pause the video and let me know which one is the correct option. Okay, we'll see which one is the correct. The writ of prohibition is issued before the final order is passed by the judicial or quasi-judicial authority. No, the prohibition is issued yes, before the final order is passed, because prohibition talks about the inactivity. Okay, it prohibits the lower court or the tribunal when there is a possibility of the lack of jurisdiction or excess of jurisdiction. So that time it prohibits the lower court or the tribunal to pass any order. So it is issued before the final order. Second, the writ of certiorari issued after the final order is passed for quashing the same. Yes, because it is the curative one. Okay, if the final order is passed and after final order passing, it court got to know, Supreme Court, High Court, that the particular tribunal or the lower court has no jurisdiction over this case. So in this case, to take the curative measures, this particular certiorari writ can be passed. And the first case, it is the preventive kind of. So it, before the passing order, it can be passed. And the first, this prohibition it is available only against the judicial and quasi-judicial bodies. Okay, but second, this certiorari is available against judicial, quasi-judicial, plus in addition to this public bodies which affect the rights of individual. If certain public body it is impacting the rights of individual, what kind of rights? Right, freedom of speech and expression, freedom of livelihood or occupation. In these kinds of rights are violating by the public body, that time also certiorari can be passed. Last statement, like the writ of prohibition, the writ of certiorari is considered a jurisdictional writ. Certiorari is jurisdictional writ, but the prohibition is the not jurisdictional writ. So it should be unlike. Okay, so the third statement become the wrong. Correct answer is A, that 1 and 2 are correct. We'll move towards the next question. It is again about it is describing one writ and asking you to find which one it is. Now everybody got to know, we are going through sequence, everybody knows which kind of writ it is. But for the sake of revision, I will take this. It is issued by the court to inquire in legality of claim of a person to public office. Second, it prevents illegal usurpation to public office by the person. It can be issued only in case of public office of permanent character created by statute or by the constitution. Third, it cannot be issued in case of ministerial office or the private office. Last one, the writ can be sought by any public minded person, not necessary by the aggrieved person. So it is talking about the writ of quo warranto, and this particular writ, it is enforced against the constitutional office as well as the statutory office, except the ministerial office. And the recent example is under this particular quo warranto, there was one case went into Supreme Court in 2021 when the government of India, it extended the tenure of ED director. Okay, previously before the 21 there was a law which allowed to hold one person the office of director for the 2 years, but later on government came with amendment that given the three extension, that plus one, so one person can hold till the 5 years now, but previously that was the only for 2 years. And when the government reappointed or extended the tenure of that director, that time case gone in Supreme Court under quo warranto, and question came in 2022 films as well. Okay, so that's why the current affair becomes very important when it comes to polity. We'll see the next question. It is about Article 33. Okay, it talks about Article 33. It says Article 33 empowers the Parliament to abolish fundamental rights of members of armed forces. The second statement, the law made under Article 33 cannot be challenged in any court on the grounds of contravention of fundamental rights. Third statement, the law enacted under Article 33 can also exclude the court martial from the writ jurisdiction of the Supreme Court as well as the High Court. So pause the video and answer the question which is the true with respect to Article 33. Okay, we'll see. First, when it comes to Article 33, it is about the armed forces and their fundamental rights. Now, when the Article 33 comes, it empowers the Parliament to abolish fundamental rights of members of armed forces. It is not empower Parliament to abolish, but it empower them to restrict or abrogate. Okay, but it not allow Parliament to abolish. So first statement becomes correct. That's why you need to read the words very carefully. Okay, and when who comes under armed forces, it comes the police forces, the military, it comes the paramilitary forces come, intelligence forces come, analogous forces comes. So which are perform this function of the arms or the arm related forces, they all comes under the armed forces. Second, the law made under Article 33 cannot be challenged in any court on the grounds of contravention of fundamental rights. When it comes to this armed forces, there is restriction to enjoy their freedom of speech and expression, freedom of association, okay, or assembly, and other fundamental rights. These fundamental rights are restricted, and when this law is made to restrict this kind of law, it cannot be challenged on as a contravention of the fundamental rights. So that's why this statement is correct, because Article 33 gives the power or empowers the power to restrict the enforcement of fundamental right with respect to armed forces. Okay. Third statement: the law enacted under Article 33 can also exclude the court martial from the read jurisdiction of the Supreme Court and High Court. This is also correct. The court martial, this can be excluded from the read jurisdiction, because under read jurisdiction, person can go to enforce his fundamental rights, and fundamental rights are restricted. So that's why the statement 3 is correct. Everything is interlinked. Okay. So the correct option is the B. 2 and 3 are correct. We'll see next question. It's about Article 34. Talks about Article 34. It provides for the suspension of the fundamental rights while martial law is in force in any area. The expression of martial law has been explicitly defined in the Constitution as a situation where the civil administration is run by the military authorities. Last statement: the Parliament can also validate any sentence, passed, punishment inflicted, forfeiture, order, or other act done under the martial law in such area. So pause the video and answer the correctly. Okay, we'll see it. The Article 34, it is about the martial law, and it is inspired from the English common law. The martial law, it means the military rule. Okay, it means that the civil administration is run by the country. Civil administration run by the military authorities for purpose of restoration and maintenance of law and order. Okay. So the first statement, the Article 34 provides for the suspension of fundamental right. Martial law is in force in any area. Correct. The expression of martial law has been explicitly defined. Whenever such terms comes, it will be wrong, because Constitution has hardly defined anything. It is left on the Parliament to decide or the define on by bringing some laws. Next, the Parliament can also validate any sentence, passed, punishment inflicted, forfeiture order or other act done under the martial law in such area. Yes, Parliament, after the enforcement of martial order, whatever the military does in the particular area, be it any sentence passed against any person, they give the punishment, they seize the properties, okay, or any other act done under this martial law. So Parliament can validate them. So second and third is correct. Okay, C is the correct option. The first two, the 1 and 3 are correct. Okay, second is the wrong statement. We'll move toward the next question. It is about Article 35. It says Article 35 lays down the power to make law is given to the parliament to give effect to certain specified fundamental rights. Article 35, it is empowered both parliament and state legislature to make law on the subjects in union list, state list to give effect certain fundamental rights. Okay, it's quite easy question, but still try to attempt. Okay, we'll see which one is the correct. Article 35, it lays down, it is about the giving effect to the fundamental rights. Okay, the conditions that applied in fundamental rights as well as the punishments. Okay, so punishment when it comes to the forced labor, untouchability. So these kind of offenses are there where the parliament, constitution asks the parliament to bring the law to punish this one. So it talks about the give effect to these fundamental rights to the by bringing the laws, or to give effect to certain provisions of fundamental rights such as the writ. So we have seen the writ, the power to enforce writ can be given to any court, and this can be given by the parliament. Okay, again Article 33 we have seen. 34, okay, the parliament has power to violate the all actions during military rule, or Article 33, parliament has power to restrict the fundamental rights of armed forces. Okay, so to give this effect to this kind of the fundamental rights, the parliament can bring the law under Article 35. Okay, so first statement says it lays down the power to make a law give effect given to the parliament to give effect certain specified fundamental rights. Yes, just only I discussed, as well as fundamental right and the prescribing the punishment for the offense that mentioned in the constitution. Second, Article 35 empowers the both parliament and state legislature to make a law on subject of Indian list, state list. This is the wrong, because it is Article 35, it is empowered only the parliament. Only the parliament can bring the law to specify the punishment. Okay, to give the punishment or to give effect to the fundamental rights. Okay, in any case, if this to give effect the fundamental rights or this punishment, it comes under the state list, then also the only parliament can be, or the parliament has the power to enforce them. Okay, as well as they have the parliament, they in normal situation also they have the power to enforce the union as well as the concurrent list. But there are only 5 circumstances where the parliament can exercise this, or the exercise or the bring the law on state list. Okay, to addition to this 5, this is the one, that is Article 35. So the second statement is wrong, first is correct. Correct option is A, that is A1 only. We'll see the next question. It is about the article that omitted from the preamble, constitution, is right to property. Now it says that right to property is constitutional right, though no longer fundamental rights. Right to property is part of the basic structure of the constitution. Tricky question. Take a time and answer it. Okay, we'll see. Just we'll give the brief overview of right to property. When the originally constitution enacted under Article 19, there were 7 fundamental rights, or the 7 rights. Okay, fundamental rights under Article 17. One of the right to property, but there were several cases happened when the Supreme Court and the Parliament came in conflict. The first constitutional amendment was there, the 7th came. Okay, subsequently many amendments came then they were about they're revolving around the right to property. So finally, when the 44th constitutional amendment came, that time what the parliament did, they removed right to property as a fundamental right itself, but they have added as a and article 300 somewhere in last part, but still it remains as a constitutional or legal right. Okay, so the first statement becomes the correct. It is still the constitutional right but no longer fundamental right, and right to property is part of the basic structure. This is not correct because it no longer fundamental right, so it no longer basic structure. It is said by the Supreme Court. Now when it comes to legal rights, constitutional right and fundamental rights. So fundamental rights are the right which are mentioned between the article, the fundamental rights which are mentioned between article 12 to 35. Okay, these are the fundamental rights. When it comes to constitutional right, these constitutional rights, these are the all the rights that's present in the only constitutions, or the constitution only present in constitution. These are the or only constitutional right. When it comes to legal right, these are the fundamental rights. They includes the constitutional right. In addition to, they includes the statutory rights also. So when it comes to legal rights, they can be fundamental rights, they can be constitutional right, and they can be statutory right. But when it comes to fundamental rights, they are only mentioned in article 30, article 12 to article 35. When it comes to constitutional right, this all the rights they have mentioned in the constitution, including fundamental rights. So fundamental rights are also constitutional right. When it comes to legal right, the all the rights that mentioned between the article 12 to article 35 means fundamental rights, and also the mention in constitutional right, these are legal right. In addition to this, statutory rights like right to strike, okay, Industrial Establishment Act, that are given right to strike as a statutory right. So when it comes to legal right, it includes fundamental right, constitutional right, and the other statutory right. So this you need to remember. Now when it comes to this question, correct answer is the A, that only one is the correct. We'll move towards the next question. It is again about the right to property, because right to property is in news nowadays, and the case is going in Supreme Court. Okay, already the Supreme Court come with one judgment. So kindly let me know the which is the that case. So when it comes to this question, it talks about the right to property in India. So first statement says it can be curtailed, abridged, or modified without constitutional amendment by the ordinary law of the Parliament. Second, it protects private property against executive action but not a legislative action. Second, third statement, there is no guaranteed right to compensation in any case of acquisition, requisition of private property by the state. Okay. Now the which statement are the correct? Okay. There is only one statement of 3 years correct. Let me know which one is the correct. Okay, we'll see which one is the correct. Actually, the option should be only one. The only it should be like this. Only one, only two, only three. Okay, how many statements are correct? So to trick you, I said the only one statement is correct, but we'll see which is exactly correct. It can be curtailed, abridged, or modified without constitutional amendment by the ordinary law of parliament. Yes, because it no longer fundamental right, so it can be regulated as an ordinary law by the parliament. There is no need of the constitutional amendment. Second, it protects the private property against executive action but not legislative action. This is also correct because it is constitutional right. And we, when it comes to our constitution, procedure established by law, it applies. So under the procedure established by law, the executive action, if this is arbitrary, then then only this particular arbitrary executive action can be struck down by the Supreme Court or the High Court. But when it comes to there is legislative law. Now be it fair or be it arbitrary. So when it comes to this procedure established by law, when Parliament or the state legislative assembly comes with the law, with be it fair or be it arbitrary, that time the court cannot be taken or cannot say it is a wide. So in this case, what is the correct? This statement becomes correct because the legislative action, through legislative action, person can be like this property can be taken off. When it comes to the third statement, there is no guaranteed right to compensation in case of acquisition of private property by the state. This is also correct. Okay, many of you would have thinking about the exceptions, but this exception not applies to this right to property because it's talking about right to property that included in Article 300. Okay, not articles that included in fundamental right. When it comes to fundamental rights, fundamental right to property. Okay, there is no fundamental right to property explicitly present in constitution, but there are the two provisions which talk about the right to property or the right to compensation. They not talk about the right to property. So the right to property is not constitutional fundamental right, but right to compensation is a fundamental right, and this is fundamental right in only two cases. Which two cases? First case is the when the land, the property that government is going to acquire, it is under the or within statutory ceiling prescribed by the government. Mostly the state government prescribe the statutory ceiling. Okay, and this particular property or the cultivable land is between the statutory ceiling. That time the person has the right to compensation, and this particular provision added by the 17th constitutional amendment. Okay, second case when the person has the right to compensation, it is the minority educational institutions. This just we have seen Article 30. Okay, in this case, when minority educational institutions, if the government wants to take over their property, then government must give them compensation. So these minority educational institutions have the right to fair compensation under Article 30. Okay, 30, and this particular provision added in the constitution by the Article 44th Constitutional Amendment Act. Okay, so this is the two exception. There not exception. We don't have any exception for the right to property, but we have the right to compensation, and that only in the two cases. Okay, we'll move toward the next question. It is about Article 31. Okay, it talks about the Article 31A. It immunizes the state law from the judicial review if it has received the precedent assent. Second statement, it provides for the guaranteed right to compensation in case of acquisition of private property by the state if the land is within statutory ceiling limit. That is just I was talking about. So still decide whether first statement is correct or not. Okay, we'll see which one is the correct one. So when it comes to this Article 31, it is added by the first constitutional amendment, and the first constitutional amendment, it is related to land reforms. So when the government was implementing land reforms in the 1950s, that time the many zamindars, okay, they went to Supreme Court challenging the land reform laws under their right to property. So when they went and right to property, that time government brought the subsequent amendments to curtail their right to property and to make the land reform successful. And in when this conflict started, this was the first amendment and the first article that government inserted, the Article 31A, which immunized the state law from the judicial review. The received from the president assent. Yes, this is correct. State laws means the state government's law or state legislature's laws. When these particular laws receive the president assent, they immunize from the judicial review. Okay, so this is the one aspect. This particular statement is correct. Now it provides, and when it comes to this article, now this we have seen that this is correct. Okay, it is guaranteed right to compensation in case of acquisition of private property by state, and the land is within the statutory ceiling limit. So this is the correct, just we have seen. Okay, now when it comes to Article 31A, this particular Article 31A considered as exception for the Article 14, as equality before law, and Article 19, that is the certain freedom given by the Constitution. Okay, the 6 types of freedom that we enjoy, this is considered exception. And there are the 5 categories of the law that talks about the first. It is really related to amalgamation, acquisition of the estates. To erstwhile princely states were there, to acquire their estates. This particular amendment, the particular article used. Also the amalgamation of the corporations. Okay, when the British left, that time the many corporation was there, government wanted to amalgamate their corporation, that time this article used. Also to change the limits, change the rights of the director within the companies. Some companies were there, that time also this article where, if you are aware of PCR framework, okay, prompt corrective actions, which previously it is brought by the RBI. Okay, this used to limit the rights of director, the distribution of their dividend. Okay, these are also used to do by the RBI, and so this is particular article that gives this right. Okay, so this is about the Article 31. So when it comes to this statement, the both are the correct one. Okay, we'll see the next one. It might be about Article 32. So there is one case which talks about this particular. There is description of that case, and you need to identify which is the case. Okay, this case invalidated provision inserted by first constitutional amendment 1951 to provide immunity to act and regulation from judicial review. Second, the Supreme Court held that judicial review is basic feature of the Constitution and cannot be taken away by placing law under 9th schedule. Okay, it reversed the judgment given in Vaman Rao versus Union of India. So which identify which is the case in this 4-1. Okay, this is quite easy one. In this, with this word only you can identify. Okay, we'll see. So it talks about the, basically it is case of the IR Coelho case, because it talks about the 9th schedule. So this first constitutional amendment, okay, it brought the inserted one article, Article 31B, and this Article 31B, it brought the 9th schedule. In the 9th schedule, if Parliament inserts any law, okay, any law in the 9th schedule, then what will happen? This particular law will be immunized against, that law will have the immunity against the judicial review. Okay, so mostly to include the laws related to land reform, government brought this particular amendment and insert this article and this particular schedule. But later on, we have seen the violation of this spirit behind this particular amendment. The government started including various laws which taken away what was the core purpose of 9th schedule. So finally, in IR Coelho case, Supreme Court said that the law it is inserted on the under article, the 9th schedule, if it violates Article 14, Article 15, Article 19 and Article 21. If this law, the law included in 9th schedule, they violates this particular article, which forms the basic structure of the constitution, okay, there is a basic structure of the constitution, then that can be challenged. And it also reverses the Vaman Rao judgment. In the Vaman Rao judgment, what it said? It said that the laws included, okay, basically when the judicial review as a basic structure established in the case of the Keshavanand Bharati. So Keshavanand Bharati case happened in 24th April, okay, 1973. So in Vaman Rao case, what Supreme Court said, the laws that included in 9th schedule before this 24th April 1973, they will not be challenged. So judicial review will not apply against them. But in this particular IR Coelho case, what Supreme Court said, even the laws included before on the 24th April 1973, and they are violating these rights, then these laws also can be challenged. So judicial review can be enforced against this such kind of law. So now whether you include in 9th schedule, you include now or you would have included before this 24th April 1973, okay, still these laws are open for the judicial review. And currently the case is going on is Tamil Nadu reservation case, that is under this particular this development, this case is going on and it is pending in Supreme Court itself. Okay, we'll see the next question now. Might be about this is the last question, I guess. So it is the crux of the fundamental rights. So you will get some crux, what is the fundamental rights. Okay, so fundamental rights, the Constitution has defined the terms public order, minority, reasonable restriction and the public interest. Second, the fundamental rights mainly consist of political rights and make no provision for the important social and economical rights. Okay, they lay down the foundation stone for the social equality and social justice. Now tell me which is the correct one. Okay, we'll see which one is the correct one. First, it is defined, just I said, if this kind of terms comes, then statement will be wrong, because constitution hardly has defined any term. Okay, so the first statement is wrong. Second, the fundamental rights mainly consist of political right and there is no provision for important social economic life. What kind of, so this is correct because constitution has not given specific social economic rights like right to employment. Okay, these kinds of rights has not given in the constitution, so the statement is correct. But they lay down foundation stone for social equality and the social justice. This becomes correct because the fundamental right, IDA beyond the fundamental right is the liberty. Liberty means the political democracy. When political democracy is there, this political democracy, what it does, it puts or restrict, what it restricts, arbitrary power of state. So it is restricting arbitrary power of state, means it is ensuring the equality. And this particular aspect included in Article 14, which talks about the rule of law. Okay, when there is a rule of law, the social justice or the social equality is visible. Okay, so this is about this particular article, and with this, hope we are finished all the fundamental rights. I have taken the 3 parts, but I have extensively covered all the fundamental rights starting from Article 12 to Article 35. So I have given you all the exception involved, what are the keys or what are the traps are there in all the fundamental rights, that I have covered extensively. So here I am finishing the discussion. Thank you very much.